Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration.
Do you ever feel like you're spending more time on paperwork than practicing law? Many firms lose nearly half their day to outdated systems. This free guide to the best immigration software for law firms in 2025 will help you fix that. E-Immigration compares the 6 leading platforms side by side, so you'll know which software actually reduces admin work, protects client data, and helps your team work faster. Stop drowning in forms. Start practicing law. To get the guide, head on over to get.eimmigration.com/resources or save time, click on the link in the show notes.
And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. So often of late, the news at the top of this podcast has been a bit negative. And I won't lie, we live in dark immigration times. But that election was pretty encouraging, huh? More importantly, I'm sure I speak for all of you when I speak for myself. We've got to do a bit of a better job remaining positive, focusing on the good, and keeping our spirits high. This is a marathon. So here's some good. Habeases are winning across the country. I'm blessed personally. My son is a crazy person. I attended and presented at a San Diego AILA New Members Committee alongside some various teamed local attorneys this week. To an impressive group of fairly new immigration attorneys who seem awesome, smart, and hungry. We are the resistance, and we are up to it. It's November in San Diego. I just had a delicious burrito. There is so much good in this world, and not all of it makes you sleepy. Keep it in mind. Remember it. Tell yourself these things. By the way, a lot of that good is about to be discussed. Give these cases a listen. Starting off with Daley v. Choate et al., published by the 10th Circuit on November 3rd, 2025. Lots of habeas going on these days, folks. Anyone want to get paid by the U.S. government? This decision is for you. Under the Equal Access to Justice Act, or EAJA, 28 U.S.C. Section 2412, attorneys can get their reasonable fees paid for by the U.S. government. We've done at least one of these on the show stemming from Petition for Review litigation, the Kengla FAC, the Return of the FAC, episode 153. It's no small thing, and at a minimum requires a showing that the U.S. government was not, quote, substantially justified, end quote, in defending the federal lawsuit. That's not an issue at all in this case, actually, because the government didn't appeal that matter, but it's worth remembering that is the standard. This case is about whether you can claim EAJA fees following a successful habeas litigation at all. You can, said the 10th Circuit. Miss Daley is from Guatemala and was brought to the United States at 12 years old. Lord knows what happened after that, but she was eventually convicted of second-degree murder in California years later. But that conviction, was ultimately vacated and reduced to assault with a deadly weapon. She still ultimately did 15 years in prison, so no small thing. ICE tried to pressure her into stipulating to a removal order, and when she refused, ICE detained her immediately after her prison sentence and transferred her to a facility in Aurora, Colorado. She applied for asylum and related relief and protection about 3 months later. Not conclusively resolved, it seems. After over a year in ICE custody and 15 years in state prison, Miss Daley filed a habeas petition in 2022 demanding a bond hearing. And when you know it, when a district court granted it and an immigration judge was actually required to look at Miss Daley, the human being, an immigration judge deemed her not dangerous at all and ordered her release on the minimum amount of bond possible, $1,500, after she had spent 450 days in ICE custody. I don't know what then happened to her asylum claim, but after she moved the district court for EAJA fees because of the habeas win and received over $18,000. The Department of Justice appealed. Not on the substance of whether she warranted EAJA fees or not, again, but whether you can get EAJA fees at all. And as I mentioned, you can, said the 10th Circuit. Even for what would otherwise almost surely be a mandatory detention case like this, where somebody died, right? Take note, habeas warriors and AUSAs defending some of these cases that they know should not be defended. The reasons why you get EAJA fees, as explained by the 10th Circuit, it gets pretty heady. And if you're trying to make good law in a circuit that hasn't ruled on this issue yet, by all means, read this decision very carefully. Here's the gist. You can't sue the U.S. government and get money unless the U.S. government has waived its sovereign immunity. EAJA waives sovereign immunity, quote, in any civil action other than cases sounding in tort, including proceedings for judicial review of agency action, end quote. That's why you can get them if you win a successful petition for review, for example, if you petition for them. But what is habeas? Is that really a civil action? The concept of civil actions is like 200 years old in America, but the concept of habeas is so old that we use Latin terms to describe it. Going all the way back to English law, you have private and public actions. Public stuff is historically criminal violations where civil actions, quote, seek redress for an individual's private injury or vindication of an individual's private right. And to determine if an action satisfies that definition, the common law focused on the remedy being sought, not the conduct being challenged, end quote. Going through really old case law, the 10th Circuit explains that when Congress passed EAJA, civil actions were defined broadly to encompass, quote, actions brought to enforce, redress, or protect private rights, encompassing all types of actions other than criminal proceedings, and including actions to obtain personal liberty, end quote. So that sounds like a habeas detention case, right? Even though there's kind of a public component to it as well, the demand for release from state custody. But that's not unique, explains the court. Actions often involve private and public components. But ever since 1883, the Supreme Court has apparently recognized that, quote, the writ of habeas corpus is the remedy which the law gives for the enforcement of the civil right of personal liberty, end quote. String citing the Supreme Court and circuits for all of this. Now, true, there is 10th Circuit precedent that holds that a habeas challenging criminal confinement is not a civil action within the meaning of the EAJA. Habeas is weird and unique, and that just falls on the other side of the private versus public line, it seems, when the person is criminally charged and bringing a habeas action for his or her release. But habeas generally is a civil action, explains the 10th Circuit. So here, where the underlying action is also civil, you can get EAJA fees. Recall, despite it literally being the caging of human beings, immigration detention is technically civil detention, farmed out to private prisons. As of course are bond proceedings before an IJ, all civil. So the 10th Circuit has no problem allowing civil EAJA fees to successful challenges of these agency incarceratory actions. The 10th Circuit explains some other reasons and addresses some of the government's arguments to the contrary, but that is the primary stuff. It all does deserve a quote, though. Remembering the moment we are in and the point of habeas, the 10th Circuit explains, quote, habeas petitions play an important role in challenging and deterring unlawful detention. Yet the high cost of retaining an attorney to file a petition can dissuade many people from doing so. The cost barrier is especially high in the immigration detention context. Immigration is a sprawling and complicated area of law that can be difficult to navigate without the aid of counsel. It is also difficult for those in immigration detention to afford counsel because they are unable to work while detained. The availability of EAJA fees and habeas actions challenging immigration detention therefore plays an important role in lowering financial barriers to filing such actions, end quote. I see you, 10th Circuit. And unstated by the court, but I imagine giving AUSAs pause and something to talk about with their client when deciding whether to settle. the availability of EAJA is a big deal. Really helps the pro bono firms too, explains the 10th Circuit, which is important. And to hold otherwise, explains the court, may force some people to just accept removal who shouldn't. And the court's not going to let the U.S. government use detention to force people to give up their cases any more than is currently happening. Explains the court in so many words. Chalk up a win for due process, y'all. The 10th Circuit also doesn't believe all this a huge deal, noting only 338 habeas cases filed out of 38,000 detainees in 2024. I don't know though, 10th Circuit. I bet those 2025 immigration habeas stats are through the roof. Doesn't undermine your decision. Let's all just move along. This decision here conflicts with decisions out of the 4th and 5th Circuit, so that's too bad. No EAJA fees for habeas in those circuits. I don't know if any circuits have agreed with what the 10th Circuit is holding yet, actually, which might make this decision even a bigger deal, might be creating a circuit split in a very non-citizen-friendly way. I don't see any circuits cited. Go forth and make good law in the other circuits, everyone. And hit up these folks when you do. There were so many people and entities involved in this one, including but not limited to the Guild's NIP, RFK Center for Constitutional Rights, NIJC, AIC, and AILA on amicus, repped by the law firm Cleary, by the way. Screw it. Amica was on amicus too. Peter Cameron Alfredson and Amelia Christine Dagan from Amica. As was Gibson Dunn, with John V. Hoover and a bunch of folks from Arnold and Porter litigating the case in chief. I'm naming the big law firms alongside the NGOs because we live in a time where big law has had to make a choice, and these firms chose to defend U.S. principles rather than bend the knee, it would appear, at least in this case. Right on, guys. And that is Daley v. Choate et al. That was a lot, huh? Did I get you revved up? Next is Martinez-Martinez v. Bondi, published by the 4th Circuit on November 5th, 2025. This case is about good moral character. Jaime Martinez-Martinez is from Mexico and was charged with some unnamed misdemeanor offense that landed him in removal proceedings. He's here without authorization, it appears, but for a long time, and so he applied for non-LPR cancellation of removal. On that application, he listed one alias, Jaime Martinez-Hernandez. Remember, his real name is Jaime Martinez-Martinez. At his merits hearing, he sought to amend his application to include another entry into the United States in April 2006. He confirmed that he used that alias, the Jaime Martinez-Hernandez one, to get work authorization to the immigration judge. But then towards the end of his direct examination, he testified that he actually used another alias, Vicente Martinez-Martinez, to enter in 2006. But on cross-examination, the government alleged that he used a different alias during that time, Juan Sanchez Cabrera. Mr. Martinez-Martinez testified that he knew that he used an alias at the time, but he couldn't actually remember the name. But also, he didn't recognize that Sanchez Cabrera name. And also, regardless, yes, he used a false name at the time, and he kept reiterating that he didn't remember all the names that he's used in his life, but he was conceding to using a false name. The immigration judge was not pleased, probably because Mr. Martinez-Martinez had originally told him that there was only one alias, and denied cancellation based on a finding that Mr. Martinez-Martinez lacked good moral character under INA Section 101F6, because he had provided false testimony in an effort to obtain immigration benefits within the last 10 years, during that hearing. His failure to disclose the Juan Sanchez Cabrera alias in pursuit of cancellation. The BIA affirmed, believing that actually Mr. Martinez-Martinez probably did use that final alias. After all, DHS made that allegation in I-213, so it must be true. Mr. Martinez-Martinez did win, however, at the 4th Circuit, with some big holdings along the way. First, Patel. This is, after all, a challenge to the denial of non-LPR cancellation, a statutory listed and Patel-discussed form of relief over which jurisdiction review is severely limited. Certainly of factual issues. Like in Mr. Patel's case, did he lie? Kind of the same here? Well, no, that's not what the Fourth Circuit sees as the argument. It sees something more akin to what the Supreme Court said courts could review in the post-Patel decision, Wilkinson. The BIA's, quote, decision that an applicant falls within one or more of the ineligible per se categories is not a discretionary decision, but rather a legal determination involving the application of law to factual findings, end quote, over which the court has jurisdiction. It's a mixed question of law and fact, application of fact to a legal standard. Here, the good moral character legal standard defined at 101F6 of the INA. Now, in no small part, review is also happening because of a 2006 Fourth Circuit decision called Jean v. Gonzalez, which the panel holds remains good law post-Patel and Wilkinson. So there you go, Fourth Circuit guys and gals. The nerdiness is actually a bit deeper too, and it's because of good lawyering. Quote, Mr. Martinez-Martinez contends that the BIA improperly applied Section 101F6's false testimony bar by conflating false testimony with concealment, contrary to Supreme Court precedent, end quote. Very interesting. And a very legal question, right? Mr. Martinez-Martinez isn't challenging what he said or what his intent was. That's probably unreviewable as a question of fact after Patel. It's more legal. And also because of the Supreme Court's 1988 decision in Kungas, wherein the court held, quote, whether a petitioner's misrepresentations constitute testimony is a question of law, end quote. Nice citation to have for a case like this. That is, when you're trying to distinguish between false testimony and concealment and get jurisdictional review. Seems like Kungas is kind of on all fours there. So on to what Mr. Martinez-Martinez actually did or did not say then, and the legal consequences. He's getting a remand, even if the review is deferential to the BIA. An issue the Fourth Circuit isn't deciding post-Wilkinson, by the way. So finally, here we are on the merits. And unfortunately, it's actually more of a standard of review thing. The BIA had held that it saw, quote, no clear error, end quote, in the EAJA's false testimony finding. The problem with that is, as we've discussed, Section 101F's analysis is a mixed question of law and fact, which therefore must be reviewed by the BIA de novo, essentially anew, not for clear error, that deferential standard of review that Mr. Martinez-Martinez convincingly argued is what the BIA did here. Because they said clear error, right? That alone is getting the remand, so no big holding on the true scope of INA Section 101F6 and whether concealment constitutes false testimony, although the panel definitely leaves some crumbs along the way. Great win. So congratulations, former AILA National President Jeremy McKinney, along with his team in Greensboro, North Carolina, on this win. Dara Arroyo Longoria from his friend also expressly listed. Rock on. And that is Martinez-Martinez v. Bondi.
Not sure what to do when a client asks you about the EB-5 investor visa or how they can choose the right EB-5 project? That's where EB-5 support comes in. Founded and led by veteran immigration attorney Irina Ristova, EB-5 support helps investors navigate the entire process of EB-5 project selection and provides complimentary training for immigration attorneys who want to strengthen their EB-5 petition filing skills. Visit eb5support.com. That's eb-5support.com. Or click on the link in the show notes. Access their online attorney portal for training tools and practical resources, or schedule a time to speak with the team. All project guidance is provided by FINRA-registered financial professionals, so you and your clients can proceed with confidence. EB-5 Support, where immigration law meets investment expertise. Securities offered through Sequence Financial Specialists.
Doing business as Invest America. As you heard, we have a new sponsor. Check them out. They are pretty cool. And a lot of you have come up to me at these conferences asking how you can learn more about EB-5. That's your way. Anyway, for this next batch, we're going to do 3 from the Fifth Circuit before concluding with a banger out of the 11th. The first from the Fifth is Rosa, Arevalo v. Bondi, published by the Fifth Circuit on November 5th, 2025. This case is about motions to reopen and equitable tolling. Mr. Arevalo was ordered removed, physically removed, and re-entered the United States unlawfully. Removal proceedings were in 2004, and it all stemmed from an Illinois-controlled substance conviction. In 2023, Mr. Arevalo learned of a new 2021 Illinois law that might enable him to vacate his conviction. Remember, he re-entered unlawfully? He took advantage of that new law, and in December 2023, his conviction was vacated, literally based on, quote, procedural and substantive deficiencies in the underlying proceeding, end quote. So a flat-out immigration law qualifying vacature. But he still had a problem. Not only does he have a removal order, but it's been executed, and he entered again unlawfully, subjecting him to possible reinstatement. And a reinstated removal order generally can't be reopened or reconsidered. Now, lucky for Mr. Arevalo, ICE did not reinstate this removal order, and in January 2024, he moved the BIA to reopen. I guess he had appealed it all way back when. And yet the BIA denied because, why not? I don't actually know why we're in the Fifth Circuit with an Illinois conviction. I guess that's where removal proceedings must have occurred despite the Illinois offense. But anyway, the Fifth Circuit affirmed here the denial of the motion to reopen. That motion is, after all, 19 years untimely from the 90 days that someone has to move to reopen their removal order. Those 90 days can be equitably tolled, but to do so, quote, the first element requires the litigant to establish that he pursued his rights with reasonable diligence, not maximum feasible diligence. And the second element requires the litigant to establish that an extraordinary circumstance beyond his control prevented him from complying with the applicable deadline, end quote. Mr. Arevalo urged the Fifth Circuit to begin the diligence clock when the Illinois law came into effect in 2021 that permitted vacature. But even assuming that date, he still didn't pursue vacature for 2 years. Now, Lord knows how non-citizens are supposed to learn about these changes of law immediately, and there are circuit decisions recognizing and forgiving this reality, discussed on the pod in the past. But also, equitable tolling and due diligence can be a tough burden. Applied tough here. Quote, he provides no evidence of the steps he took to pursue his legal rights for almost 2 years while the law was in effect, end quote. More so, once he learned of the new law in 2023, quote, because up to 8 months may have passed from the time he learned of the Illinois law to the time he sought relief in state court, we cannot, without more, say the BIA abused its discretion in finding a lack of diligence, end quote. Apparently, Fifth Circuit case law already precludes an argument that the diligence clock begins when the conviction is vacated. So, can't get that date. Meaning that Mr. Arevalo, with no criminal convictions, remains ordered removed. And that is Rosa Arevalo v. Bondi. Next up, Calderon-Uresti v. Bondi, published by the Fifth Circuit on November 6th, 2025. The Fifth Circuit is bringing us a bit back down to earth this week with their multiple non-citizen baddies. This one about the Violence Against Women Act. Miss Calderon-Uresti came to the United States as a child, 15 years old, fleeing mafia members who kidnapped her in Mexico. She saw SIJ status but aged out, it appears. Arrested for a DWI in 2018, removal proceedings began. By this point, she had been in the United States for about 7 years, but her notice to appear was deficient, didn't have the date, time, or location of the first hearing. She then married a man named Francisco, who was a U.S. citizen and who she'd been with for a long time. She had already had children with him. But she does have an unlawful entry, so she can't adjust to LPR status in America. About a year later, she asserted a claim for VAWA cancellation of removal in proceedings, claiming to have suffered extreme cruelty from her spouse Francisco. And that is very much a basis for VAWA cancellation of removal, which also has some other friendly eligibility requirements that Ms. Calderon-Uresti appears to have met, like favorable continuous physical presence requirements, for example, as compared to non-LPR cancellation. It's still discretionary, though, and only if you have indeed suffered battery or extreme cruelty from your U.S. citizen or LPR, spouse, children, or parents. I do believe parents are listed, but check me on it. Mr. Calderon-Uresti testified that after her 2 children were born, Francisco, quote, became physically and emotionally abusive, would insult her, tell her that she was crazy, claim that she was a slut, and wanted to be looking at other men, and say she was not worth anything. She suffered this treatment almost every day, end quote. He wouldn't let her leave the house. Tried to hit her with a car, it seems, and she was hospitalized. Beat her up in front of the children and hit the children. Police were called at least once. The children sometimes had to step in to stop the harm. On one occasion, the police, quote, they photographed bruising on Miss Calderon-Uresti and her son and generated a police report, end quote. Constant unwanted sexual attempts as well. Food and plates thrown at her. Seems horrible. But Miss Calderon-Uresti didn't actually present the police report in court. Quote, her lawyer conceded in closing argument that the fact that we do not have the police report or those photos hurts our case, end quote. I don't know what to say there. Didn't have the hospital records either. The immigration judge remarked, quote, don't you think those are pretty important when you don't have anyone who can corroborate that you were abused, end quote. And Miss Calderon-Uresti said, quote, honestly, yes, but I forgot, end quote. The EAJA deemed her credible but denied. No witnesses to testify. No corroborating evidence. The BIA affirmed, and the Fifth Circuit did too. Pretty tragic all around. Now, the Supreme Court's Wilkinson decision gives the Fifth Circuit jurisdiction over some of this. Something good. Quote, the core of this dispute is whether the record evidence meets the statutory eligibility criteria. That is exactly the type of mixed question courts can review in the special rule cancellation context, end quote. So right on. But the Fifth Circuit just affirmed. Even where deemed credible, explains the court, an EAJA and the BIA can deny pretty much any relief application based on a finding that the non-citizen, quote, could reasonably obtain corroborating evidence, end quote, but didn't. As such, the record isn't so compelling to the court as to mandate reversal of the BIA. No discussion in the decision, one way or the other really, about how domestic abuse of this nature affects a non-citizen's ability to get evidence in support of their abuse claim, which is unfortunate. Now, Ms. Calderon-Uresti also argued that the BIA erred in failing to address her clear eligibility for regular non-LPR cancellation, something she became eligible for on appeal, post-Ms. Chavez, because the stop time rule never kicked in, and then she got her 10 years, right? Problem is that she never made this argument to the BIA, whether on appeal or in motion to reopen form. So it was unexhausted, explains the Fifth Circuit, meaning she lost. I suppose Ms. Calderon-Uresti could now move to reopen with the BIA, though. Matter of Chen, if I'm not mistaken. And that is Calderon-Uresti v. Bondi. Moving on to Dominguez Reyes v. Bondi, published by the Fifth Circuit on November 6, 2025. This case is about aggravated felonies, money laundering crimes that exceed $10,000, as defined at INA Section 101A43D. Mr. Dominguez Reyes is from the Dominican Republic and obtained lawful permanent resident status in 2007. Pled guilty in Florida in 2022 to federal money laundering conspiracy, though, in violation of 18 U.S.C. Section 1956H, because of course it's Florida. That's a flat-out Section 101A43D aggravated felony if the $10,000 threshold is met. The Supreme Court and later case law holds that the first money laundering portion of the aggravated felony statute is subject to the strict categorical approach. But 1956H is flat-out mentioned. So then the $10,000 loss amount, case law explains, permits a circumstance-specific approach inquiry, which in turn permits consideration of certain conviction-adjacent documents. In this case, quote, a forfeiture order attached to the judgment of conviction reads, the court hereby finds that at least $3,934,518 was obtained and laundered by the defendant as a result of his participation in the money laundering conspiracy, for which he has pled guilty, end quote. Does that satisfy the circumstance-specific approach and removability? It does, says the Fifth Circuit. First, explain the court. Circuits can consider forfeiture orders during the circumstance-specific approach inquiry. The court believes that follows from the Supreme Court's seminal decision in Nijuan itself. That forfeiture as a post-conviction penalty is not dispositive. The Supreme Court has already ruled, says the panel, that, quote, sentencing-related material from the record of conviction can be considered so long as those materials are tethered to the specific counts covered by the conviction, end quote. Of course, then, Mr. Dominguez-Reyes argued that the forfeiture order here wasn't sufficiently tethered to his conviction, mostly because a forfeiture order need only be based on a preponderance of the evidence, rather than a conviction which must be shown beyond a reasonable doubt. Problem is, says the Fifth Circuit, that the BIA rejected this argument in its 2007 decision, matter of Babaisakov, affirmed by the Second Circuit precedentially on direct petition for review. At least under circumstances where the forfeiture order wasn't contested in the criminal proceedings, there isn't evidence in removal proceedings of error in the criminal proceedings, and where the forfeiture is like a lot more than $10,000. Careful listeners will note, however, that the Fifth Circuit and the BIA and Babaisakov are saying that extrinsic evidence can be considered by IJs during the circumstance-specific approach. Note it. But in this case, all those Babaisakov factors weighed against Mr. Dominguez-Reyes. The forfeiture order here was also sufficiently tethered to the money laundering charge that he pled to, expressly. That quote I read above is quite clear to the Fifth Circuit, particularly as Mr. Dominguez-Reyes was the only defendant named in the forfeiture order, and again, no evidence was offered to dispute the findings. Sufficiently tied to the money laundering conviction to the court. That Mr. Dominguez-Reyes may have only profited $10,000 or less is besides the point to the court. It's the amount of funds involved in the laundering that matters, and here, the Fifth Circuit believes that that amount is in the millions. So Mr. Dominguez-Reyes lost his case. And that is Dominguez-Reyes v. Bondi.
Imagine this. He couldn't remember the reason for the meeting. When his colleague asked for updates, his mind went blank. And that's when he realized he's pushing himself too hard. Late nights, non-stop notifications, constant fear that if he stepped away, everything would fall apart. For our hypothetical attorney, enough was enough. This holiday season, he's choosing to be present, not just available. With Staffy, you can too. Their 24/7 Staffy Live specialists will answer every call and qualify every lead, so your firm keeps growing even when you log off. And with Staffy Outsourcing, you can delegate your first 3 cases completely free of charge if you sign up for the service before the end of the year. You built your firm for freedom. Let Staffy help you live it. Visit staffy.cc to start spending time on what truly matters. That's staffy.cc or call at 786-891-5619. Or of course, click on the link in the show notes.
Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833 409-9200. And so we come to the end. I teased it mid-episode. It's a big deal. United States v. Miller, published by the 11th Circuit on November 6th, 2025. It's a big one. And I must admit, I must pat myself on the back because no one else will because I'm speaking into the void. I kind of called this when I did the Supreme Court's Brown v. United States decision, episode 213. Go back. Check the tape. This decision arises in the Armed Career Criminal Act context, but regards the federal definition of a controlled substance and whether Florida's definition of cocaine meets it. So yeah, it's a big deal, because Florida, right? As so often is the case with these, if Florida's definition of cocaine matches the federal definition of cocaine, Mr. Miller is getting a lot more time in prison for his federal felon in possession of a firearm and ammunition convictions. Possibly as much as life in prison, as opposed to a 10-year max. So yeah, the stakes are high. But Florida cocaine does not match the federal definition. Big caveat, the cocaine version at issue here, in play at the time of Mr. Miller's previous 2017 offense in Florida for selling cocaine. The crime that he was convicted under is Florida Statute Section 893.131A, but I'm not sure it really matters because it's really about the definition of cocaine. Let me explain. The categorical approach applies, of course, but that is only the beginning. The 11th Circuit is one of the growing list of circuits that has concluded that drugs can be broader than the exact same named federal drug. In the 11th Circuit, despite the BIA trying to put its head in the sand, that is the Syed decision, recognized that Florida's marijuana definition is broader than the federal marijuana definition, meaning Florida criminalizes more conduct. In every circuit except the Fifth Circuit, a criminal defendant or non-citizen need not find an actual prosecution to win the day on this. Quote, with the categorical approach, a court looks only to the state offense's elements, end quote. The 11th Circuit has said as much multiple times now. Logically, all of this should apply to drugs like cocaine and methamphetamine, too, that are made out of different chemical compounds, not just out of different seeds and stalks and stems. If, for example, Florida criminalizes possession of more type of meth than do the feds, then Florida meth possession would appear broader than the federal definition, meaning a sentence should not be enhanced and a non-citizen should not be removed for Florida meth possession, for example. The 11th Circuit blurred things a little bit with its Shamu decision, episode 92, but that was really just because it didn't actually believe the overbroad Florida cocaine isomer discussed in that case existed. The 11th Circuit left open the possibility that it might, though, by the way. Anyway, no circuit requires that a non-citizen find an actual prosecution of overbroad conduct to satisfy the realistic probability test with a textually overbroad criminal statute, except the Fifth Circuit. Which is why the BIA's episode 275 decision, matter of Felix Figueroa, is not worth the electronic paper that it is written on. Anyway, here we have Florida cocaine again, like in Shamu. And to my recollection, the 11th Circuit hasn't expressly adopted the isomer or different chemical compound argument yet. Theoretically, that is. Seems like it has now. Quote, a state conviction qualifies as a serious drug offense only if the state statute under which the defendant was convicted defines the offense in the same way as, or more narrowly than, the ACCA's definition of a serious drug offense. End quote. That same rationale would apply with immigration, as the ACCA depends on the same federal drug schedule definitions as does immigration law. As relevant here, the federal schedule defines cocaine as, quote, cocaine, its salts, optical and geometric isomers and salts of isomers, as well as cocaine, its derivatives, their salts, isomers, and salts of isomers, end quote. Here's where the Supreme Court's Brown decision comes in. We're not going to chemistry class. As Justice Alito explained therein, quote, before 2015, this definition covered ioflupane, which is the active pharmaceutical ingredient in a drug used to diagnose patients who are suspected to have Parkinson's disease, end quote. But surely because of the Parkinson's stuff, Congress then exempted ioflupane in 2015 from the federal schedule, meaning the cocaine derivative, ioflupane, was no longer a federally criminally controlled substance after that. Let's turn to Florida then. First, the 11th Circuit concluded that Section 893.131A is divisible as to the drug type possessed or sold, what have you, meaning that it can look to the conviction documents and see that, yes, Mr. Miller possessed and tried to sell cocaine. No small holding, but also it follows quite a bit of 11th Circuit precedent, holding the same with similar Florida drug statutes already. That's only half the battle, though. What does Florida have to say about cocaine and ioflupane? Well, first, Florida's cocaine definition is not further divisible into separate elements. The different cocaine derivatives are means of the offense. Indeed, there's even a Florida appellate case where an individual was convicted under this statute twice for possessing and trying to sell, two different types of derivatives of cocaine. Explains the 11th Circuit. Pretty strong evidence for indivisibility. And yeah, these derivatives actually exist. Quote, before July 2017, this provision did not include any carve-out to permit conduct involving ioflupane, end quote. Supreme Court said that in Brown, by the way. That means there were about 2 years there where someone could be convicted of possessing or selling cocaine in Florida in a manner broader than federally criminalized. That's how you win under the categorical approach. Now, you'll never guess when Mr. Miller was convicted. August 2017. Just after Florida got rid of ioflupane, meaning that his Florida definition of cocaine conviction actually matched or was narrower than the federal definition. No mismatch when he was convicted. But when he committed the offense in February and March 2017, there was. Because again, Florida didn't change its definition to get rid of ioflupane until July 2017. So what are we to do? Well, actually, even the U.S. government here agrees that you look to the definition of the crime when the offense was committed. That follows quite directly from Brown v. United States, although after recognizing that, the 11th Circuit spends a fair amount of time additionally explaining why. And some of it may be ACCA specific, but I think it's a fair bet that it applies in immigration world too. Read this and Brown carefully, though. Read it. Ribbit. And there is a caveat that is quite complicated, so I'll just quote the whole thing. Quote, to put it more succinctly, in most cases, a federal sentencing court applying the categorical approach will look to the version of the state law in effect when the defendant committed the state offense. But this will not be so if the state law changed between when the defendant committed the offense and when he was convicted of it. The change narrowed state law, and the state law has no saving provision, end quote. I'll get to savings provisions in a sec. But restated, it's an exception that I believe further helps criminal defendants and non-citizens avoid collateral consequences in unique circumstances, kind of giving them the best of both worlds. Anyway, applying the general rule here. Florida's cocaine definition was broader than the federal definition when Mr. Miller committed his offense, because Florida criminalized ioflupane, as Justice Alito said. We already said this, actually, just returning. But again, remember, he was convicted later. Now, at the time of his conviction, and I think today, Florida's Constitution actually did have a savings clause for drug offenses, but had a constitutional provision that made it such that criminal defendants in active prosecutions don't benefit from it. That is, favorable changes in law. It would appear that what this decision is saying, and I'm no criminal law expert, is that if you are arrested and charged with something, and then the law narrows later, you can still be convicted based on what you did when the law was broader. Like Mr. Miller here. By the time of his conviction, he could have still been convicted for possessing ioflupane, because that's what the law was when he was charged. The savings clause doesn't apply to him, which is a big deal and a big help under the categorical approach. It means, explains the 11th Circuit, that it looks to the definition of Florida cocaine at the time Mr. Miller committed the offense, which was, again, overbroad There was about 2 years there when Florida cocaine was broader than federal cocaine. Indivisibly so. Meaning Mr. Miller wins. He doesn't have a serious drug offense. He's getting much, much less time from his federal firearm conviction. Is your head spinning? Here's some immigration takeaways. The takeaways to me, at least. Hit me up if I've missed something. The 11th Circuit is totally down to consider whether chemical drugs are broader than the federal definition of that same drug. It flat out affirmed the cocaine derivative argument and noted in a footnote that the isomer argument, related argument, isn't settled in the 11th Circuit. But I see no reason why it wouldn't apply so long as you can get over Chameau and prove that your overbroad isomer actually exists in the world. Another takeaway, when comparing drug crimes, in most circumstances, you're looking at the definition from the time of commission, unless your state has a law that permits individuals in active criminal proceedings to benefit from favorable changes in law, a savings clause. Florida apparently doesn't, or certainly didn't in 2017. And finally, I believe that we're then comparing the federal definition at the time of conviction to that state definition that really is at the time of commission. That's not actually any different in this case, but I believe that's the holding of Brown and additionally the BIA in matter of Dorr, episode 256. But check me on that too. Are we having fun yet? And that is United States v. Miller.
So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.